When around 200 people marched through downtown Boston for the so-called Straight Pride Parade over the weekend, they were met by nearly 3 times as many counter-protesters. Ultimately, more than 30 of those protesters were arrested after clashes with police, but District Attorney Rachel Rollins, who campaigned on leniency for low-level crimes, instructed her prosecutors to dismiss charges against several people charged with lesser crimes like disorderly conduct, resisting arrest, and at least 3 more over a lack of probable cause. But during arraignments yesterday, Municipal Court Judge Richard Sinnott said no to nearly all of the prosecutors' requests. As arraignments continued today, Judge Sinnott did agree to drop several charges, but tensions escalated further when he held a defense attorney in contempt. So, did the judge cross the line? And is it about these cases or about Rollins' approach to criminal justice? The attorney held in contempt, Susan Church, who's representing one of the protesters, joining me now. Susan, thank you for being here.
Thank you for having me.
Along with former prosecutor Brad Bailey. Hello, Brad. And Nancy Gertner, retired federal judge and senior lecturer at Harvard Law. Judge Gertner, it's good to see you. I should note we invited members of the police union who were in court for the arraignments, told reporters they were there to, quote, make sure the DA prosecutes all of these offenders to the full extent of the law. We did not hear back from the union. Nancy, you described, Judge Gertner, you described the actions of the judge as, quote, not in the zone of legitimate, as lawless. You want to explain a little bit?
The judge has no authority under the law to refuse a null pros, which is the prosecutor essentially wiping out the charges. And he has no authority to deny a motion to dismiss. We're a system of division of responsibility. He can't prosecute the case if the prosecutor doesn't choose to. And the rule expressly says this is a prosecutor's decision.
Well, if it's as clear as you say it is, obviously the judge would know that, would he not?
You would think he would, but, you know, I don't know what he was doing. I don't intend to speculate, but it really was not even, it was lawless from beginning to end.
Does the judge have the power that Judge Gertner says he does not have, Brian?
Well, I respectfully disagree. On a motion to dismiss, the judge has the ultimate authority on that. When a prosecutor who is the prosecuting charging authority files a null pros, that's different. He cannot object to that. He cannot let that go through because the DA has the right to go forward on charges. But asking a judge to dismiss, the judge technically can say no.
The rule expressly excludes the judge's authority to deny a motion to dismiss.
But why was there a motion to dismiss to begin with? If the DA has this power, why doesn't the DA just not proceed with the case? Susan?
Just to be clear, my client was being null pros, so then we all agreed that the judge was acting lawless and out of the bounds of the law. My case was set to be null pros. The DA's office had informed me that that's what the DA's office asked for.
But there was a motion to dismiss, as Brad
not
said.
on my client.
Oh, not
when
on
I was arrested.
I'm sorry.
Right.
Can you explain? Actually, I meant to get to this. I didn't know this would go on. But tell us, why were you held in contempt? What did you do that offended the judge?
I tried to explain to the judge what the law was, which was that he has no authority to deny a null pros, that he can't refuse to enter it, he has to accept it. I literally was handcuffed and brought to the lockup downstairs. As I was explaining to him, there's a case exactly on point that is binding precedent that he must follow if he's a judge that follows
the law. So you literally just reading the law to the judge?
His position is I interrupted him after being told not to. But I interrupted him because he wouldn't let me speak. So I know you've been in this situation where you're trying to talk to somebody. I just wanted to read this one case to him because the quote was exactly on point, and he handcuffed me and brought me downstairs. I was astonished.
By the way, I don't mean why you here in the weird way it sounds.
I was here because I was in jail all day.
How are you here? You were in jail.
So I was by an amazing community of advocates and lawyers, a bunch of people, including my own husband, who is a defense lawyer, came to the courthouse to represent me. I was brought. I don't know what happened, but everyone was planning on filing emergency motions and appeals, and a lot of lawyers came in and out of the courtroom and made their present known, including reporters, and next thing you know, I'm let out of the courtroom.
Can I get back to the original discussion, Brad, with you for a second? You said the judge did have the power in this case because a motion was made to have the cases dismissed. Do you know of any other cases you could cite where a judge exercised the power you say he has and they both says he doesn't have, where it was upheld?
Well, I agree with Susan. On a null pros, he does not have that authority.
Where
and I think
there's
the
not a
rule
motion
is about
to dismiss.
Null process. I've seen it happen on motions to dismiss. I've seen judges say, if you want this dismissed, you file the null pros, you file the instrument that says you're not going forward.
Are you troubled by Susan Church having been held in contempt for what she did?
Very much so. Absolutely. She's a highly respected attorney, and attorneys ought to have leeway to argue and advocate for their clients. That's what the court forum is all about. So yes,
There would have been a lot of lawyers in prison for interrupting me. I got 17 years of interruptions. I mean, and interrupting me on an issue of law, of course.
Yeah. But am I reading too much into this to suggest that a judge who decides to hold someone in contempt for that sort of behavior is somebody who has some concern about his own decisions? Is that too much psychoanalysis?
I think you got to be careful reading anything into things other than the inappropriateness of what happened under these circumstances. I do think that this is a judge, for whatever motivation, wanted to put everything on the district attorney, and that's what he was trying to do here.
Can I address this? I think that's really important. I have represented protesters for 20 years. I represented the Occupy protesters. All of their cases were dismissed with and this is under Dan Conley. This is not under Rachel Rollins. I don't think I've ever represented protesters who's been convicted. Their charges get dismissed. And why is the judge so resistant to this? Is it because Rachel Rollins is the district attorney? Is it because he's opposed to her political view of the way she prosecutes?
One of the last times she was here, we talked about how the former head of the DA's Association, I think former now the Cape and Islands DA, had written an op-ed essentially about her. The police union obviously has not been crazy about her.
Right.
You're suggesting some of the judges aren't either.
In court, he asked her. My understanding is he asked the prosecutor, "Why are you doing this?" Well, that actually is not his decision.
Right.
The why she's doing it is, I was elected to implement a policy. I have a right to. The judge, it's not an issue for the judge.
Can we read? Let me read what Rachel Rollins had to say. She put out a statement after the judge denied the motions to dismiss in some of these cases. I'll just read part of it. By compelling arraignment in every case, the judge punished the exercise of individuals' First Amendment right to protest. At my request, prosecutors use the discretion constitutionally allocated to the executive branch, etc. She goes on to say, make no mistake, some people were appropriately arraigned, will be held accountable. People engage in violence or assault, that sort of thing. And she ends with saying, for those people now tangled in the criminal justice system for exercising their right to free speech, many of whom had no prior criminal record, I'll use the legal process to remedy the judge's overstepping of his role. She cites the First Amendment twice, Judge Gertner. She never talks about the judge not having the power. She says overstepping, but not nearly as strongly as you do. She doesn't. Is she in the same place you are, or no?
I think she is in the same place. I mean, she's talking about the impact. She's making a political decision. The impact of what he did on their First Amendment rights. And, I think that she's being cautious. It's easy for me to say this judge was outside of the zone of legality because I never appear in that court, right? It's easy for me to say, and it's true, but I think that that's the difference.
Should something happen to him as a result? What?
Well, two things. I mean, one is I think that the issue has to go up to the Supreme Judicial Court to make it clear that the rule means what it says. And then I think
the DA has unilateral power in this case.
Really, notwithstanding the notion that it may happen sometimes, there's literally a rule that says that a prosecutor has a right to dismiss an annul pros situation. And then the notes to that rule says in federal court, there is an authority when there's a motion to dismiss that the court has to approve it.
But this
we
was not,
expressly choose
you're
not
saying
to do
accepting,
that.
Okay, but continue your thought. What else should happen to the judge?
There could be disciplinary proceedings against the judge. I mean, you think about it. Let's step back a little bit from this. There's a judge who Dan Connolly, the former DA, went against because he didn't like his sentencing. This was in the judge's discretion. There's a federal prosecutor now going after Judge Joseph. He didn't like the way she managed her courtroom.
Andrew Lelling, right here.
This is a different issue.
Do you think this, to follow up on what Susan said, do you think this is about Rollins' criminal justice policy?
There's no question about it. I think that when you strip away, there's no other explanation for it.
Do you share the perspective of your two colleagues here? This is about the bigger picture. It's not really about just these cases?
I think it absolutely is about the bigger picture, but it's very important.
Does that not trouble you, by the way?
I mean,
what is he making a policy pronouncement about her position on criminal? I mean, the Attorney General of the United States, Barr, essentially called these people, like the Rollinses, like the Krasners in my hometown of Philadelphia, social justice reformers and anti-law enforcement DAs. It seems to me that this judge is essentially continuing the crusade, no?
But I don't want to burst bubbles, but this isn't that unusual. As a former state and federal prosecutor, I'm holding Susan contempt is highly unusual. A different issue.
And refusing a null pros is
But-
unusual.
and refusing a null
Never
pros
seen that
can't
before.
happen.
Right.
But refusing to be the one to dismiss charges on a motion, look, I've had that happen to me as a prosecutor, both in state court a number of times.
But if the
doesn't
refusal
make
to
it
dismiss is
file.
based upon the policies of the prosecutor,
Right.
that doesn't trouble you? Because you all seem to be
Right.
saying that's what it is. You wanted to say something.
Absolutely. And I think the other thing that it is absolutely a problem because it's the judge interjecting his political opinion on the case. But imagine the chilling effect on other lawyers. Like, I happen to be a lawyer who's well connected in the community. I've done a lot of work. I know a lot of media. I had a barrage of people rushing to me. Imagine the young criminal defendant with nobody to protect him or her. Imagine a young lawyer who makes this mistake of interjecting the judge
But also
twice.
the notion
Just imagine
that
what's going to
the
happen
notion
to
that
them.
the police union was there to make sure that the law was enforced.
Yeah.
They don't have that obligation. That's the prosecutor's
Right.
obligation.
And the irony of that is the whole objection of the judge was that, quote unquote, the victim hadn't been notified of the fact that she was dismissing. He was citing the victim rights statute. The courtroom was packed with police officers. I heard them cheer when I was handcuffed and led away. So this politicization of our courts in a country where the rule of law is essential to our democracy is extremely concerning.
Judge, you get the last 15 seconds, as you always do. Go ahead.
Well, I mean, if it's a politicization because someone we elected as district attorney made a decision as to what her priorities for prosecution were, and if that's so, the judge doesn't have a right to second guess
Judge
that.
Gertner, it's good to see you. Thanks so much, Brad. Appreciate your time.
Thank you, Jim.
Susan, I'm glad you're out.
Thank you.